Hello, and thank you all for attending. This is Scott Trowbridge, and I'm here at the ABA, Center on Children and the Law. And this is a webinar, part 2, on special immigrant juvenile status for judges. This is where we're answering questions we had from the first round. I think a lot of people were on that, but if you weren't, it was recorded. This is being presented by the ABA Working Group on Unaccompanied Minor Immigrants and the ABA Judicial Division. We have some questions that we received on the first webinar and also via email after the first webinar. And you can also ask questions through chat. With that, I'll turn it over to Christina Cooper.
Thank you, Scott. This is Christina Ritchie Cooper, also with the ABA Center on Children and the Law. Our panelists answering questions today are the same experts we had on during our October 27th webinar. And again, they're responding to questions that were posed during the last webinar or have been submitted via email. And hopefully we'll be able to also answer any questions today. The webinar is geared toward the practice of state court judges and the state court judge role in special immigrant juvenile proceedings. So I will reintroduce our speakers. Judge Catherine Estrig serves as a circuit court judge in Florida's 13th Judicial Circuit in Tampa. The administrative judge for her Sixth Circuit's Unified Family Court, as well as the administrative judge for that court's Juvenile Dependency Court. Judge Estrig has also served as a domestic relations and criminal court judge. Angie Young is supervising attorney at the Immigrant Legal Resource Center in San Francisco, which is a nonprofit that provides legal trainings, educational materials, and advocacy to advance immigrant rights. Angie specializes in issues related to immigrant youth, the immigration consequences of crime and delinquency, and immigration enforcement. At this point, we'll start with the questions we had received or were posed during the October 27th webinar, beginning with the role of judges. Specifically, what is the role of state court judges in screening who may be eligible for SIJS? And so should the judge or court personnel refer the youth to an immigration or other attorney, and if so, when? Judge Estrig, can you begin by speaking to those questions?
Yeah, let me talk about it. And we talked about this at our first segment a little bit, the role of state court judges in screening who might be eligible for SIJS. And I think it's important as backdrop to remind everyone that there are different roles between the federal immigration system and our state courts. And additionally, there's an inherent tension between the purposes and roles of our federal immigration system and our state courts. And it's important to understand this because sometimes I hear in my state, which is Florida, different judges saying, I don't understand why I'm getting involved in federal matters. I don't understand immigration law. I don't know why I'm being asked to render orders to be used for federal immigration purposes. But you have to understand that the federal immigration law is looking to us. Federal immigration law does not consider best interests of children, whereas, of course, state juvenile courts do consider, and family courts do consider those things. And so it is up to us as state court judges in rendering our determinations if whether or not under state court law it is in the child's best interest or a child is a victim of abuse, abandonment, neglect, or what have you, to make those findings and to provide that information to the federal immigration courts because they look to us to make those types of decisions. They're not charged with those types of things. They don't handle those types of things. They're not often judges or lawyers who are handling those immigration matters. So they're looking to us who are experts in those things, and those are what we do in our everyday work in our many, many cases that we see, to determine whether or not a child meets those criteria that we have set forth, and to make findings and render orders that then may be used in the federal system, perhaps, if those findings are made appropriately and properly documented. So that's the role of the state court judges. We don't determine anything with regard to immigration. That's not our role. All we do is render our orders, make the appropriate findings, include the findings that we know are important to make if, in fact, we are determining that the criteria have been met, and then allowing them to go forth if they choose to do so, to seek SIJS in federal court.
Great, thank you. Could you address the question of should the judge or court personnel refer the youth to an immigration or other attorney? If so, when? Has that been a situation you found yourself in the SIJ matters you have heard?
Typically, the children that come before us already have attorneys handling those immigration matters. We typically don't refer them. That's not to say that we couldn't, shouldn't, or wouldn't, however. Typically, though, by the time they've come to court, to our state court system, they have counsel already in place to handle those immigration matters.
Also, we've heard that practices vary by jurisdiction. The ability of the court could be limited by a state law prohibiting courts from asking parties about immigration status during court hearings. One option would be for the judge to ask the child's attorney or the GAL, guardian ad litem, whether he or she has explored SIJ or other relief options for his or her client, speaking more generally.
Well, here in California, we have a law called AB 12 that extends jurisdiction for youth and juvenile, both dependency and delinquency from 18 to 21. And some courts have found through the Judicial Council forms that they are required to ask whether or not the agency with custody of the child has sought SIJS if the youth may have an immigration issue. So some places have taken this affirmatively to screen for some of these youth and point that as an issue.
And in Florida, we have a similar law with regard to children who are already in our system of care, and the requirement for our Department of Children and Families to do so as well.
Thank you. Next slide. We'll now move on to the category of questions under procedural paths, but of course, if anyone has questions about what you just heard, feel free to submit them to Scott, as well as presenters. If there's anything else you want to add, feel free to do so at any time. Regarding procedural paths, Angie, could you begin by responding to these questions? How are unaccompanied and other immigrant children generally ending up in state courts? And which state courts are best suited to hear SIJ matters?
Great. So we know that, there are many children that are abused, neglected, or abandoned, but may have different procedural paths in the United States of how they end up in court. And so typically we've seen about 4 different areas of how youth may end up in the court system and end up asking for special immigrant juvenile status findings. So, and just to proceed, there's about basically 4 different areas that we've generally seen this, and all courts in different states have different names, but they could be in a case where a youth, including an unaccompanied minor, experiences a breakdown after unifying with a parent or just living with a parent and suffers abuse, neglect, and abandonment, and CPS is called. And so they may end up in child welfare or dependency proceedings. And that's typically where kind of SIJS was born out of looking at those kinds of cases. There are also unaccompanied minors or immigrant children that may have interaction with law enforcement and get arrested and end up in delinquency or the juvenile justice system. They, too, may potentially seek special immigrant juvenile status. And then increasingly in the last few years, we're seeing more youth in 2 other types of proceedings. One is if they are in the United States without a parent or a legal guardian, they may need to have a guardian appointed, and they may end up in guardianship proceedings. And then finally, there are youth who are already safely residing with one parent, and have experienced abandonment, abuse, or neglect from the other parent. And the parent with whom they reside may wish to seek full custody of the child, and so they may end up in custody proceedings. All of these different kinds of proceedings may be called differently in different states. You may move general courts of jurisdiction, juvenile court, family courts. But the real thing here, though, under federal law is that a juvenile court is defined very broadly. It is any court in the United States that has jurisdiction to make determinations about the care and custody of a child. So, the name of the court is not determinative. It's really about the role of the courts. And so that's why there's a broad range of courts that may be contemplating and can look at the special immigrant juvenile findings. And then to just answer this other question, what state courts are best suited to hear SIJS matters, because of this broad definition, there are a variety of courts, any court really, that can hear issues regarding the care and custody of a minor is suited to hear that. And that's really aligned with the most recent iteration of the Special Immigrant Juvenile Status in 2008 statute, which indicates that you not only could be Special Immigrant Juvenile Status eligible if you're dependent on, which we kind of think more of the dependency child welfare proceedings, but also that you could be Special Immigrant Juvenile eligible if you are appointed to the custody of an individual, agency, et cetera. And that has really left room, as you see on the slide, for other types of proceedings that people that customarily thought that weren't eligible for Special Immigrant Juvenile Status to be eligible. So that includes guardianship, custody, and delinquency as well. So I'll leave it there for right now.
Thanks, Angie. Judge Esrig, in your county or in your circuit, do different judges in different courts hear SIJ matters, or are they regularly sort of funneled to a particular judge or a particular court?
We previously had all of our dependency court judges handling them, but we now have one special division and one judge who handles all of them. It just was easier for scheduling purposes. That's not to say that the other judges aren't capable of doing it. It's just that for scheduling purposes, we found it was helpful to have a particular division where all of these cases were set, and we try to even do specific days when we handle those cases to the extent we can.
And Angie, is the practice in California or in different counties in California different?
Yeah, it just depends on different places. I mean, like in Los Angeles County, which I think handles more special immigrant juvenile petitions than any other county in the United States, they have a whole unit, right, just dedicated to these issues. And then, you know, our courts are bifurcated, so we have delinquency court judges hearing delinquency, dependency, and then the separate for probate, guardianship, and family. So this is a really county-by-county approach of how they hear these cases.
We will move to our next category of questions unless the panelists have anything else they want to share at this point about the procedural paths of these matters. Why should a court issue a custody order to a parent when the child already lives with that parent, especially if the other parent has abandoned the child? Can a child be considered abandoned by a parent who has died? And to what extent does USCIS question state court orders?
Okay, regarding the first two questions, again, the particular circumstances of any case are going to govern. The only requirement from federal law is that reunification with one or both parents is not viable due to abuse, neglect, or abandonment or a similar basis under state law. There's nothing other than that in immigration law or in USCIS guidance to dictate the question of the one-parent custody orders or the abandonment question otherwise. There's not a federal policy against a finding against just one parent, even when the child is living with the other parent. For example, I mean, there are many reasons why a parent might seek a custody order, even if the other parent, the abusive or neglectful parent, is no longer in the home, or even has abandoned the child or the family. For example, a non-abusive parent who had been subject to domestic violence by the other parent may want a custody order so that it's clear who the child is living with, who can make legal decisions regarding the child, and just to have a sense of certainty and stability. Regarding the question about whether a child can be considered abandoned by a parent who has died, again, that is a matter that is based on state law. It's a matter of state law to determine if a child is abandoned by the death of that parent. If the child is otherwise eligible for SIJS and the appropriate findings have been made, USCIS would be able to find the child for SIJS, no matter what the underlying definition of abuse, neglect, or abandonment is. Again, that's the matter for state law. Regarding the question about whether USCIS questions state court orders or to what extent, it may be helpful to remember the different roles of state courts and of USCIS. The state court has a role to make child welfare related findings under the state's law. They consider applicable state laws and make findings that are based on the petitioner's requests or not. The state court itself does not grant SIJ status or any other form of immigration relief. It's the federal agency, USCIS, that determines whether the child meets the statutory requirements for SIJ classification under federal law. And to do that, they're going to look at the petitioner, the youth, or the child's SIJ petition and any supporting documentation, which should include the state court order. We believe USCIS will review the order that is submitted to make sure the requisite findings are included and that they're based on factual findings particular to that case rather than the order being a sort of template order with the specific statutory language replicated rather than the facts or findings particular to that case. If USCIS, in reviewing a petitioner's application for SIJ status, finds that the court order does not include the requisite findings or perhaps has too general language that again is more of a template order rather than one particular to that case, CIS can issue a request for evidence, an RFE, that is issued to the petitioner, not to the court, requesting additional evidence. The petitioner in those cases has a specific time period in which to submit additional evidence to USCIS, or USCIS can issue to the petitioner a NOID, a Notice of Intent to Deny. And again, the petitioner would have an opportunity, probably shorter, to reply and submit more evidence, but that's the role of the federal agency in the sort of second or third steps of the process. That's quite distinct from what the state court is doing in the initial steps, which is considering the request for specified findings and making findings based on the facts presented and the evidence presented to the court in a particular case. What else do our presenters have to add about any of these questions?
It does not, I'm only familiar with Florida law with regard to that, and that is not, death does not constitute abandonment under Florida law. I don't know about other states, however.
I can, in California, the California law defines abandonment as leaving the child without provisions for support, and death is actually considered to be a similar basis to abandonment since willfulness is not required by the statute. And so the appellate courts here in California have agreed with that interpretation in an unpublished decision.
We may move on to the next category unless there's anything else panelists want to add right now.
Okay, moving on to the next question. USCIS says that state orders are not supposed to be sought for immigration purposes, but aren't immigration purposes a major factor in requesting SIJ findings? I think it's clear that there may be mixed motivations on the part of someone who is seeking both, for example, a custody order or guardianship order and findings related to special immigrant juvenile status. A youth may both need protection under state law and in some form and the immigration benefit. I think what's important to note is that the federal law doesn't charge state courts with examining the motivations of the youth or a child appearing before the state court. The requirements under state law don't change. The findings being requested either can or can't be made based on the circumstances of the case and the state law, and that's the role of the court to address in each case. Do our other presenters have anything to add regarding this question or other elements of the role of the state court? Do our other presenters have anything to add regarding this question? I lost it, sorry. Oh, shoot. I can't remember what I was going to say.
Huh?
I thought of something better, but I can't remember now. Do our other presenters have anything to add regarding this question or any other related aspect of the state court role?
Again, I remind the state court judges that, you know, our role in handling these cases generally, not just those involving children who are going to be seeking SIJ status, is looking at safety, permanency, well-being, and in my opinion, their ability to subsequently go to federal court to pursue that status is part of their seeking safety, permanency, well-being matters, which we are to consider.
Thank you. Then we'll move on to our next category of questions, and it really is regarding current issues in state court SIJ practice. So we've kind of outlined a few hot topics or current issues here. And I welcome any comments that we have from our panelists, and perhaps starting with you, Angie.
Great. I will talk a little bit about some changes in law in at least a couple of places of late around extensions of jurisdiction. And really these states are New York, Maryland, and California, and I'll take a minute to summarize each, as this may happen in other states as well. So as of about 2007, New York's guardianship statutes were amended to extend the benefits of guardianships to consenting children over 18 and under the age of 21. This amendment wasn't made for special immigrant juvenile status, but it is applicable to and regularly used by children seeking guardianship and special immigrant juvenile status findings. And one purpose for this is that, you know, under federal law, we know that a child can be eligible for special immigrant juvenile status up to the age of 21, but in many states, jurisdiction terminates at 18, and so some of these youth are locked out of options from that age point to be able to stabilize their immigration situation. Last year, in 2014, in Maryland, HB 315 was passed, and it really altered the jurisdiction of an equity court to include both custody or guardianship of an immigrant child pursuant to a motion for special immigrant juvenile status. And what they did was they changed the definition of a child to include anyone unmarried under the age of 21 under specified circumstances. So it did allow these children in the age of 18 and under 21 to be able to seek special immigrant juvenile status and be under the jurisdiction of both custody or guardianship. Under the similar vein, this year in California, our California governor signed AB 900, which similarly extends guardianships. It doesn't do custody from the 18 to 21 for purposes of special immigrant juvenile status. And it, again, changes the definition of child to someone who is unmarried and is under the age of 21. The purpose of these bills that I think are more special immigrant juvenile status is not solely or primarily only to seek special immigrant juvenile status as immigration status, but it is looking at some of the best interests of these children. So, for example, in Maryland, one of the main impetuses for this was to curb homelessness by ordering a guardian or a custodial parent to be responsible for a minor, and they recognizing the importance of a responsible adult in these children's lives, especially as some of these children as accompany minors are just learning English, learning to integrate and be acquainted with American society. And similarly here in California, I think given our population and a great number of unaccompanied minor youth, the legislature has been concerned with responding to the unaccompanied minors that have been coming and assisting these newcomer youth in addressing their vulnerabilities and understanding that when they turn 18, it's not as if everything is settled and fine and they're fully integrated, that many of these youth, even as they arrive in later in teens, are still adjusting to American life and may need that support from a guardian. I don't know if anyone has any comments about that to add.
Angie, have you heard any of any similar legislative efforts in other states?
We haven't as of now, but I think this conversation might happen in Illinois. Don't hold me to that, but that might be possible. But as of now, no. But I think there's definitely probably discussions in some other places, even initial ones.
And are these laws recent enough that you haven't seen, or not you, but the courts haven't seen many related cases quite yet, or advocates and haven't seen how the cases involving older youth have proceeded at the USCIS level?
Well, I think in New York, this has been, from what we've heard from practitioners, this has been commonplace for quite some time. We're looking at 8 years. So this is something that's regularly done. I think Maryland's newer, and it seems that people are able to do this. I don't know. I'm sure some of those cases have come up before USCIS. We have more reports. In California, our law was just signed. It does not go into effect until January 1st, 2016, so it's too early to see, what impact and what this would look like on the ground. And obviously this is, some of this, we do have a lot of different county practices, so we'll see how this works county to county as well.
I think we are getting a couple questions, and I would just remind participants to submit questions through the chat box on the bottom right. We will, after discussing a couple other current issues, open it up for questions that have been sent in, or if people find it more comfortable to verbally ask the questions, then we can unmute your phone as well. But at this point, can the panelists continue to talk about current issues, whether about any useful or interesting case law or recent case law or other hot topics you identified with regards to special immigrant juvenile proceedings?
This is Angie again. I could highlight this recent case. I know that there's different cases that happened, but I think this is significant because this was from the Supreme Court of New Jersey, and I could do a quick summary of it without getting too much in the facts because they get complicated. So in this case, HSP versus JK and KG versus MS, we're looking at two different scenarios. One were custody proceedings involving a mother with her two children from El Salvador. And then another case, and the father was murdered in El Salvador, so, they were just living with the mother. In another case, this was a young man who was seeking guardianship and was living with an uncle. His father had abandoned him at the age of 4, and his mother had sent him to the United States. And there were questions of whether or not she neglected him because he was basically kind of forced to work in India. And so I think this case, beyond just the facts of this, really do clarify a number of the issues we've talked about today in the first webinar. And if I could just highlight kind of the 4 main points that the Supreme Court made, especially as it relates to what are the state court rules. One, I think it just reiterates what Judge Esricks was talking about, the role of juvenile courts, and really it states that the findings made by state courts only relate to matters of child welfare, and that's specifically the determinations of abuse, neglect, and abandonment in a child's best interests, and that was really how the Special Immigrant Juvenile Status Law was designed. The second thing is, what is the applicable law standards when you're looking at abuse and neglect and abandonment? This came up because there were questions of an HSP's case that his mother neglected him in India, and they were putting a standard of neglect in India as opposed to the United States. And the Supreme Court disagreed with that and said the SIJS statute requires states to apply state law on abuse, neglect, abandonment, not foreign law of what happened, whether that kind of those actions were acceptable in the foreign country. Because then that outcome is different there, that they could actually find in that case that the mother was actually neglectful under New Jersey law as opposed to a standard in India. The other issue that's been a hot topic is this language around one or both parents. Is it legitimate for someone to be living with a parent and still get special immigrant juvenile status? Are they in need of protection? And the Supreme Court actually the New Jersey Supreme Court found that, this kind of interpretation is not for state courts, but for the federal court. And that they actually suggested an approach with the state courts that they should just conduct an analysis for each parent of whether or not there was abuse, neglect, or abandonment, regardless of the outcome of each of that analysis. Do it for both parents, and then allow USCIS to have that sufficient information to make that determination whether that meets the federal standards. So they're kind of staying out of those interpretations, which is a different approach than I think some other courts have made. And then the final thing is around a pre-screening of abuse. And again, here the New Jersey Supreme Court court said that this is not a matter for state courts. This is something that should be left to the federal government, that it's not up to state courts to undertake a determination of whether there was an immigration motivation in applying for SIJS. that matches Congress's intent in creating that avenue of relief. But that's really the federal government will look at that. So I'll just leave it at that. This is one of the most recent kind of high court decisions on SIJS, and I think it's helpful on a number of points that we've discussed today.
Thanks, Angie. And it actually touches on one of the questions we've received, which is someone asking to hear from Judge Esprig and Angie regarding the prior question about why court should recognize one parent SIJS when the child is with a safe parent. Do either of you want to respond to that?
Judge Esprig, do you want to?
Well, and I think the suggestion that was just raised a few minutes ago, that we as state court judges can look at each parent and talk about parent A and parent B, and then leave it up to the federal court to determine what that means vis-a-vis the one or both parents language. I understand that there's case law, and it even in my own state and in several other states, that is confusing, and different interpretations of either or both, or one or both parents rather, has come out. I know there have been opinions I've read in my state of Florida, in New Jersey, in Nebraska, in California, Illinois, Minnesota, Nebraska, et cetera. And, different ones have interpreted it different ways. And I would suggest, I think we would all like some better guidance on this. Again, I think you need to look at the state court holdings in your state, if there are opinions out of your state, as to how they've been interpreted. And, I take it to mean that either reunification with one, meaning either parent A or parent B, is not viable, or reunification with both parents is not viable, in the disjunctive. That's my personal interpretation. That's how I handle it when these cases come before me. But again, I think you're going to have to look to the law of your state as to how that interpretation has occurred. But again, to go back to what was suggested before, I don't think we need to get overly bogged down in that. I think if you take it on a parent-by-parent analysis, and you make very specific and detailed findings in your order, that it will then be up to the feds to interpret them appropriately and to make the appropriate immigration determination based thereon. And correct me if I'm wrong, but the case law that I've read, the majority of the cases from these various states have found that you can satisfy that the petitioner can satisfy that requirement by showing an inability to reunify with one parent. That's really what one or both means, and that if they had meant you have to show that reunification with both parents and alone, that they could have said that, but that's not what it says. It says one or both, not just both.
Okay. One other, and feel free, of course, to comment on any of the other questions that we've been talking about if anything else occurs to you. I think the other question that has come in is probably visible to all of you. I think is probably best answered if by any panelist, by Angie, since it refers to a number of different immigration relief options. Yeah. How do you differentiate if a case falls under battered child under VAWA or SIJS or children asylum categories? Which one is better and easier for a child? And perhaps Angie, as an immigration lawyer, and if anyone else has a response regarding to the state court practice, please chime in.
Great. Well, obviously, a lot of this is always fact-dependent, right? I mean, it's looking at the individual facts of the case and really the desire of the child or family that's involved in the case of what would make the most sense. I would just say a lot of people are not seeking VAWA as much anymore as the U visa, which has a little bit more expansive it's always benefits for folks in being able to get in. VAWA does require that the person that's abusing be a U.S. citizen or a lawful permanent resident, and that can make it difficult for some folks, whereas a U visa, which is a victims of crime visa, allows the abuser to just be undocumented and to seek certification from an agency that's going to investigate or prosecute the crime. to certify and then go through a process kind of like SIJS, apply to an agency, the Vermont Service Center. So that's one thing that can happen, and U-visas and VAWA could be preferred over something like special immigrant juvenile status if we're talking about, for example, a mother and a child that are suffering abuse from someone and that we want to seek benefits for the family, the same as a family situation, not just for the child. Special immigrant juvenile status is a form of relief that's only for the child. That child can never petition the parent, not even the non-offending parent. So if, this child has an undocumented parent, SIJS would not solve kind of the family immigration issues. So that's something to think through. Although with special immigrant juvenile status, you can get a green card, lawful permanent residence, much more quickly than you would be able to with a U visa. And then finally with asylum, asylum has a different standard. Essentially, you need to show persecution, past persecution, or well-founded fear of persecution in the future. And it's not sufficient just to show any fear. It needs to be an articulated fear that has a nexus to enumerated grounds, like a political opinion, social group. There's a number of things, and that social group nexus can be very hard for people to prove. And for example, in the unaccompanied minor youth, many of them may be seeking special immigrant status, but most of them do also seek asylum at the same time. So these aren't exclusive forms of relief. Many of them are pursuing multiple forms of relief at the same time. But sometimes the burden is so hard for some of these youth to show that the person that threatened them or their family was persecuting them on behalf of a political opinion or on behalf of a social group. Some of those nexus arguments can be very difficult, and there may not be strong case precedent for them to be able to prove that in the local immigration court. But I would just say a lot of this is not exclusive, and that many people pursue different forms of relief at the same time.
Thanks, Angie. We don't have any other questions written in at the moment, so we will ask people if you want to just verbally ask your questions over your phone lines. Just press *6 to unmute yourself if you've muted yourself, and you can ask questions of our presenters.
Can a step-parent also be considered as a parent that has abandoned the child to create eligibility for SIJ status?
That will depend on whether the step-parent is a legal parent under state law. Where step-parents can adopt, that would be a possibility. But a step-parent isn't automatically a legal parent upon marrying the child's biological or otherwise legal parent.
So, Desiree, on our last webinar, you mentioned something about a task force that you have worked on. Could you speak a little more to what your court or stakeholders did to address, perhaps it was challenges regarding SIJ or other related topics that you came together to address?
Yes. This was a multidisciplinary task force. We knew, because of where we're located geographically in west coast of Florida, that we were going to be seeing an uptick in these cases. And so we formed a task group, and we have a website, and we've distributed flyers that have different resources that are available to help really any immigrants. They don't have to be in our court system. It's really just geared for outreach to help any members of our community who we feel need help as immigrants. And we have a large Hispanic population, so we printed it in English and in Spanish, and we have a number of resources for those who don't speak English, who can seek medical care, help with education, health care, as I said, and other resources, housing, all sorts of assistance. As well as immigration proceedings, the outreach phone numbers and websites for those things as well, but it's really not specifically geared to that.
And who was it who actually created the group to begin with?
It was a number of judges and general magistrates and lawyers, specifically immigration lawyers in my jurisdiction, who just saw that this was going to be a need. And we partnered with our local university, which is the University of South Florida, and it's on their child welfare website. That's where we posted it. And we just thought that this was something that was going to prove helpful to people who really didn't know where to turn for help. And it's been helpful to us. It served two purposes. The work group also, we talk about hot topics. We've done some educational seminars within the courts and for various people in our local community with regard to these specific issues. And it's been very helpful for things such as one of the big issues that we had with and because I'm the one who handles these cases in my jurisdiction, I saw a number of issues with children getting enrolled in school, particularly if they were residing with sponsors who were not documented themselves. And we have some sort of standard paperwork that most children who enroll in school are required to bring, proof of residency, birth certificate, things that a number of our children coming from other countries didn't have. And so we've worked real closely with the school system, and that's just one example, but we worked real closely with the school system, and they've been great about being very creative in allowing children who don't necessarily have every single one of those documents to nonetheless show through alternate means who they are and how to be enrolled in school. That's just one small example.
That certainly sounds like a work group that could be helpful in other jurisdictions as well. If people have any specific questions, would you welcome them through Scott and I, funneling them to you? If questions came in from our email, can we
definitely
people interested?
Certainly. Feel free to provide them with my email address or my phone number, and I'll provide them with a copy of our flyer and our website information and all of that. So if they have something similar they would like to do in their jurisdiction, we can certainly assist to the best we can, to the best of our ability in helping set that up.
Terrific. Thank you. In the few minutes that are remaining, what other questions do participants have for our panelists?
In adoption proceedings, normally courts look into a home study done by the Social Services Department. In SIJS cases also, when you apply for guardianship, is there any mandatory requirement that one is to prove that the home environment is conducive and the person who is applying as a guardian can be a fit guardian? Like in state of New York, the proceedings can be initiated either in family court or in surrogate and probate court, right? And then again, the standard of criteria may be different from one court to another court. But my question is that basically if there is no, yardstick to measure whether the guardianship, the person applying for guardianship is basically competent enough or not, then there is a possibility of misuse of this SIJS system.
Whatever the state court would normally do before appointing a guardian or custodian would be appropriate. The federal law doesn't require anything additional or doesn't put in place any requirements the state court must follow just for SIJ proceedings.
I think it depends on what the standards are, what the law is, and what resources are available to you, and that's going to vary from state to state. I will tell you that and in my state, when I typically handle dependency cases, and I hear from other judges around the state, and I personally have experienced exactly what he's talking about. Normally, when we have our Department of Children and Families involved, they do home studies, and we have some standard documentation that we review in making determinations with regard to child placement decisions, and you don't always have those same resources available in these cases. But I would suggest to you, as a judge, that you have a fair amount of flexibility and resources available to you. And if I have a level, if my comfort level isn't there, obviously I'm not going to make any of such determination without having that comfort level. And I will sometimes bring in the Department of Children and Families in my state for the purposes of having a home study done or background checks run on someone, or someone may come in with a private home study. We have the ability here to do that privately. So there are various ways, and I would suggest to you, as you do day in and day out in handling your caseload, that you use the resources available to you and your ingenuity and flexibility in getting the information that you need in order to make a well-reasoned decision and to have the comfort level you need in order to place a child somewhere.
The only thing I'd add to that is that in every state I know about, there would be a presumption of fitness for the birth parent. So in a lot of cases, you wouldn't see a home study for the one parent, the one safe parent, as we've been calling it today.
True.
In the final minute of this presentation, are there any other comments from our presenters or quick questions from participants? And if not, we will conclude, and I thank very much our presenters for joining us on both webinars, and thank you again for again, your expertise and sharing with us both today and in October. If participants have questions, you can write to USCIS or to Scott and I at these addresses, and we thank you for being part of this webinar series on SIJS for state court judges. Thank you.
Thank you.
Thank you.